So I'd like to introduce our next speaker, which is Kristy Martire, who's from University of New South Wales, and she's also going to be talking about work in the intersection of legal forensics and psychological understanding of evidence.
Hello everyone, thank you so much for the invitation to be here. It's a real privilege, although it's a very nerve-wracking privilege, I must say, after that display. Please forgive me if I start coughing in the middle. I have a bit of a thing, so I'll try and keep that under control. So I want to talk about 3 different areas of research that I've been looking at, and really to talk about that in the context of Bayes Theorem, because the more familiar I'm becoming with Bayes Theorem, the more helpful I think it is in helping me to design my studies and answer particular questions. I want to start by acknowledging students and colleagues and contributors who have been a part of this work and who are always helping me to improve it and make it better. So I know there are many of you here who are much more familiar with Bayes Theorem than I am. I am not pretending to teach you anything about Bayes Theorem, but I understand there are also some people here who are maybe not so familiar with Bayes Theorem. This is basically the structure for the presentation that I am giving, in that I think Bayes Theorem provides a very helpful framework for thinking about how to design and analyze the decisions that are being made by people in forensic contexts. It has 3 basic components, and it says that my prior belief in a proposition, when multiplied by a relevant likelihood ratio in relation to that proposition, is going to produce my posterior probability, or my final belief in that proposition. And the studies I have to talk to you about today sort of correspond to components of Bayes Theorem. When you look at Bayes Theorem and you think about decision-making in forensic context, I think something that becomes very important, or you realize is very important, I realize is very important, is the prior belief, the prior probabilities in the forensic decision-making context. Because obviously, if you believe that people should be applying Bayes Theorem to their decision-making, it fundamentally matters, as Bill discussed, what the prior probabilities are that you're working with, because that's going to affect how everything translates in the trial. So if we accept that lay decision makers, jurors, fact finders are having to make a decision on a continuum from not guilty to guilty, sometimes I will use the terms not guilty and innocent interchangeably. I apologize for that, but I'm going to do it. There are probably many things I will do like that. If we accept that that's what's happening, they are having to form a belief somewhere along this continuum. Prior probabilities are, I would argue, a starting point for where they are going to make those decisions. It's an initial belief from which you start to then begin to make your decision. Beyond reasonable doubt, I would argue, and many others have argued as well, is a threshold for when you decide you have enough evidence that's in support of the prosecution's case to be able to classify someone as now being guilty of the offence. So under this formulation, it matters fundamentally where your priors are, because that's going to determine how much evidence you are going to require in order to surpass the reasonable doubt threshold. If you have a prior probability that's close to a belief of guilt, as opposed to close to a belief of innocence, it's going to take less evidence for you to convict, and that's fundamentally important to the evaluation of evidence at trial. I would suggest that courts are very interested in people's prior probabilities at trial, and I would argue that the presumption of innocence is a normative expectation about what people's prior probabilities should be. I think this is an act of the court trying to suggest to people what their initial beliefs should be to start their evaluation of the evidence. I am not familiar with all presumption of innocence instructions, but certainly in Australia and in many places in the United States, presumption of innocence instructions look something like this. They tell the fact finder that they should presume that the defendant is innocent unless and until they have received sufficient information to be satisfied beyond a reasonable doubt that the defendant is guilty of the crime with which they are accused. And while I believe that is a clear statement of what courts believe prior probabilities should be, when you actually go and look at the literature surrounding interpretations of the presumption of innocence, it's actually quite diverse, and there are many different positions being expressed about what this presumption of innocence actually means and what prior probabilities is trying to suggest people adopt. Excuse me. So there are those who interpret this presumption of innocence instruction as a requirement to be impartial or neutral about the likely guilt or innocence of the defendant at the start of the trial. Posner, for one, has argued that it requires people to adopt a position of even odds, that it is as likely as not that the defendant is guilty at the start of the trial, and that they should make their decision from that starting point. He's not the only person who's suggested this, but he has written one of the most entertaining papers advocating for that position. By contrast, I would say the predominant interpretation of the presumption of innocence is one which requires you to adopt an initial belief that is far closer to a likelihood, I'm going to have used that word incorrectly, that's far closer to a belief that the defendant is guilty innocent at the start of the trial. That the presumption of innocence is meant to act as a thumb on the scales of the accused side of the scales of justice, and that it's meant to act as a counterweight against the systemic prejudices and biases and imbalances that exist in the criminal justice system. So it's not really about adopting a fair presumption, it's about giving the defendant the benefit of the doubt, because there are a great many things that are acting against them in the criminal justice system as it is. And so there are other interpretations of the presumption of innocence that have been explored. Some people, and I've done a little bit of work in this area, is looking at the difference between legal and factual definitions of innocence and whether or not there are different presumptions that go with that. But suffice to say, there are two main camps, and these are those. I'm sure many of you have already done the extreme mathematical leap, which brings you to the point where you translate those two conceptual ideas into numerical interpretations. And if you were to adopt an impartial or neutral presumption, that would put you at around a 50% chance of guilt. And if you were to presume innocence, that would put you somewhere near 100%. Obviously, there is nobody who is probabilistically savvy who would say it should be 100%, because that means that there is no possibility of the defendant being guilty. And there are arguments as to how close to 100% it should be, but certainly the argument is that it should be a strong figure, close to 100%, but not necessarily exactly there. What's interesting is there's been relatively little robust empirical research, I think, just looking at how people understand the presumption of innocence instruction. If it is the fact that judges and courts are trying to guide people about what their priors should be, and if it is that Bayes' theorem is the appropriate model that we should be using, which suggests that your priors fundamentally matter to what your posteriors will be and to the likelihood that you're going to convict somebody, I would argue that it's really fundamentally important to understand how people interpret a presumption of innocence instruction, because it is how people are starting their decision-making process. Research has supported both the idea that fact finders, lay fact finders, will adopt an ambiguous or a 50-50 presumption of innocence, and research has also supported the idea that people will adopt a strong or a close to 100% interpretation of the presumption of innocence. The methodologies of those studies, I'm not going to go into it, there are some limitations with them. Many of them report medians and means, and as we'll see from the data, they are not necessarily the best representation of what's going on in the actual data when people respond to these kind of questions. So before I tell you about the data that I'm going to present, I want to give you a bit of information about the general procedure that I use. I do use Amazon Mechanical Turk. I know that displeases some people. We also replicate all of our studies in undergraduate samples, so we try face-to-face as well as online. And basically, if you don't know what it is, it's an online crowdsourcing platform where people sign up to complete human performance tasks, some of which are surveys and experiments. There are lots of things you can do to check the quality of your data. So once people sign up, you recruit them to the study, they complete online, and then you pay them for their participation. And one of the strengths of Mechanical Turk is that it does tend to give you a better representation of the population than you'll get from testing undergraduate psychology students, which is what we tend to do. So in this particular experiment, we use the Seventh Circuit instruction, but we've replicated this study and the results that I'm going to show you using very many different US instructions. We've used Australian instructions, and we've used some verbatim instructions from trials. And we've recruited Australian jury-eligible community members through MTurk and not. We've tested people face-to-face. What I'm trying to argue, I think, is that this is a fairly robust finding across all the things we've tried so far. So it's very simple. We give people the instruction and we ask them, before you've heard any evidence, what is the probability that the defendant is innocent? I ask about innocence because guilt is a legal construct and it's a different thing to the presumption of innocence. Guilty requires that you've surpassed the threshold, and so I didn't really want to go into beyond reasonable doubt and having that be part of people's decision making. So these are our participants. Jury eligible, 58% had been called for jury service, 16% had served. These are the demographic features of our samples. And what I'm going to show you here, along the x-axis is the numerical interpretations that people provided, and along the y-axis is the percent of participants who gave that particular response. And these are the data. So the mean would suggest that the mean interpretation of the presumption of innocence instruction is about 69% chance of innocence. Excuse me. But 28% of the group suggested that a 50-50 interpretation was their interpretation of the presumption of innocence. And about 39% suggested that it was a strong presumption in favour of the accused. There is some batching of the data here, so I can present that. This peak includes values from 95 to 100, and the middle peak includes values from 45 to 55. So I think this is interesting. Irrespective of which interpretation of the presumption of innocence you believe is the normative prior that's being set by the presumption of innocence instruction, these data are suggesting 2/3 of people aren't interpreting that version of the presumption of innocence. I would argue that a strong presumption is most consistent with the values of the criminal justice system, and 2/3 of participants are essentially not adopting that position. As I said, this finding is robust across numerous large Australian and US samples and different presumption of innocence instructions. And this matters because according to Bayes' theorem, if you start with a weaker presumption, it should require less evidence for you to reach a guilty verdict beyond a reasonable doubt. So I think the real question is there evidence that people's priors of a different strength actually go on to change the probability of conviction? That's something that we're working on still. I don't know the answer to that. It's quite hard to experimentally manipulate people's prior beliefs in a way that is internally valid, that a person actually has that belief. So we're still working on how to do that. Work in progress there. Okay, so the second area of research that I'm going to talk about is only going to be covered in a very small amount of detail by way of rationale to talk about the third studies. And this relates to interpretations of likelihood ratios, and Bill has helpfully given some background about this already. Basically, when psychologists and others have looked at people's interpretation of probabilities and likelihood ratios, what we tend to find is there's a substantial amount of undervaluing of the evidence. So the amount of belief change that is imposed as a result of receiving forensic science evidence in the form of DNA or fingerprints or whatever is generally a lot smaller than you would expect through an application of Bayes' theorem. If you multiply the priors by the likelihood ratio to reach the posteriors, that's very unlike the value you tend to get when you ask participants to do that themselves. This is a robust finding, not just in forensic psychology, outside of forensic psychology even. There is a world outside forensic psychology. And the undervaluing evidence is a pretty robust finding. To put it into context, we did a couple of studies that Bill has alluded to where we elicited people's prior odds in relation to a guilt proposition. We presented them with evidence in line with the Association of Forensic Science Providers table that you saw in Bill's presentation. We gave them either weak, moderate or strong, or verbal or numerical versions of the evidence, and then we elicited posterior probabilities, and we just looked at what likelihood ratio they would have had to have used to move from their priors to their posteriors. And what I'm plotting here for you is, so the blue bars are the expected, so this was the likelihood ratio that participants were actually provided in those studies. Weak, moderate and strong across the bottom there, and just to note that this is a log scale. And so when we look at the median likelihood ratios that people actually used in these different conditions, when they were given a numerical value, this was the likelihood ratio that was used, and when they were given a verbal equivalent, these were the likelihood ratios that were used. So it's suggesting that people just don't use these kind of likelihood ratios to update their values, which is understandable. Some of the values that they're being given are huge, and it's hard to update your beliefs by the amount of information that you're being given. But this raises questions. Why is this undervaluing happening? Could it be that people aren't Bayesians? I think some of us believe people aren't Bayesians, or at least they aren't very good Bayesians. But I also wanted to suggest that perhaps there are experimental artifacts involved that might contribute to this undervaluing. So if we do have an expectation that people are going to be Bayesians, we have to design good experiments that can detect whether or not they're good Bayesians. Bill's done some work that suggested that the way you elicit the information from them can affect the extent to which they can update their beliefs in line with Bayesian expectations. And what I want to talk to you about is sort of a different limitation that might be applying. So when you look at Bayes' theorem, it's very clear that it applies to the same hypothesis and alternate hypothesis throughout. So you have a prior belief in a hypothesis, you get new information that's relevant to that hypothesis, and you multiply those two things together and you come up with a final belief also in relation to that hypothesis. But in courts and in our, I'm going to say half-assed experiments that try to capture the idea of what goes on in courts, it's not always the case that our likelihood ratios are as nicely aligned with our hypotheses as might be required to get, the kind of belief updating that we would expect. So what we tend to do, what I've done in the past, and what you often see in the literature, is a measurement of people's priors and posteriors in relation to a guilt proposition. How likely do you think it is that this person will be convicted of the crime or did commit the crime with which they are charged? You measure that before, you measure that after, and that's what you look at in terms of the effect or the weight of the evidence on the decision making. But the evidence that we're giving them is not always very closely aligned to that particular hypothesis. So what we're giving them in the middle is a source level information that's related to a source level proposition. So that might be DNA evidence, it might be a fingerprint, and it might be a shoe print or something of that kind. And when you actually think about that, there are, just as Bill was suggesting in his last studies, there could be many alternate explanations that might mean that that source level information does not have a great deal of effect in relation to the guilt level proposition. So for example, in the studies that I had done in the past, it was some kind of bag snatching scenario where a shoe mark was taken from the scene of the crime. And we found, as I showed you before, when I plotted those likelihood ratios, we found substantial undervaluing in terms of the likely guilt of the suspect in relation to the Bayesian expectations. But when you think about it, the fact that there was a shoe print from the crime scene, even if the likelihood ratio associated with that shoe print is very strong, there are lots of innocent explanations that could come into play, which would mean that that shoe print may not say a lot about the guilt or innocence of the suspect. For example, how do you know the defendant was wearing the shoes at the time that they left the mark at the crime scene? Do you know when that mark was left at the crime scene? Was it left days or weeks before, or was it left very contemporaneously to the offence? And as we all know, simply having put your foot on a place where a crime was committed does not make you guilty of a crime, because we've all put our feet in many places where crimes have been committed. And so what I wanted to suggest was that maybe we're seeing substantial undervaluing, or part of the undervaluing is arising because we've maybe been a little bit loosey-goosey with the alignment of our evidence with our hypotheses, and maybe people are just behaving very reasonably given that the evidence that you've given them may not speak directly to the guilty hypothesis. Does that make sense? That was tough for me to get my head around. I know many of you are probably just sitting here going, well, obviously, but that took me a little while to come to. So we were really interested in exploring this idea. In these studies, we we created high and low relevance conditions for the expert's evidence. And when I use relevance, I don't mean that in the legal sense, although maybe I do. I don't quite have my head around the legal definition of relevance. It got a little confusing. What I mean is kind of alignment. It's alignment with the guilt level hypotheses. And so people were given, in this case, it was a automobile theft. They were given fingerprint evidence. It was 10,000 times, the observations were 10,000 times more likely if the fingerprint came from the accused same source than came from different sources. And that was the same across both relevance conditions. So I'm going to say match just for simplicity's sake. I realize that none of you mean that when you give a likelihood ratio. But in the high relevance condition, participants were told, okay, so this is the likelihood ratio, it's 10,000 times more likely. What you need to know is that this fingerprint was found on the steering wheel of the car, and the suspect is a mechanic, but this particular mechanic has never serviced this car. It's not been to the place where he worked. And so basically, this fingerprint is in an incriminating location, and there is no real reason that we can explain for why it would be there. So in this condition, you would expect that people should be able to, that this evidence is very relevant to a source level proposition, so whether or not the defendant actually left the fingerprint. And it's also relevant to a question of guilt because it's in an incriminating location, and if you believe it's their fingerprint, then it seems to suggest they did something that they shouldn't have done. By contrast, in the low relevance condition, they were given the exact same expert evaluative opinion. The strength of the match was still the same, except in this case the fingerprint was from the hood of the car. The defendant was once again a mechanic, but the car had been serviced at his place of business, not necessarily by him, but just in the days leading up. So under this scenario, the value of the fingerprint remains the same. It's still as likely as it was under the other scenario that it's his fingerprint. That has not changed. But the extent to which this fingerprint evidence then helps you to update a guilt proposition is very different. I'm not going to say it has no relevance, and it's probably much more complicated than I think in terms of Bayesian belief updating what its relevance should be. I will, however, argue that it is substantially less than what it would be in the other condition. And so in this particular study, we used what's called a within subjects design. So people evaluated both a guilt level proposition and a source level proposition before hearing the evidence. They got the experimental manipulation, and then they produced posterior values about guilt and about source. So they were, in essence, doing a side-by-side comparison between those two questions of guilt and source. In this study, we elicited prior odds for guilt and for source. So we asked, do you believe the defendant is or is not the source of the crime scene print, and how many times more likely? So we could create odds from that, and the same procedure but for the guilt of the accused. Some demographic information. And these are the data. So the yellow bars relate to the high relevance condition where the fingerprint was left on the steering wheel. The blue bars relate to the low relevance condition where the fingerprint was on the hood, and the filled bars are the source level propositions. The open bars are the guilt level propositions. And what we've plotted is the change from the prior to the posterior is just a simple change score. I believe these are 95% confidence intervals on the error bars. And what this was telling us, we believe, is that there's a significant interaction between relevance, evidence relevance, and proposition level. And so the difference between the two blue bars is greater than the difference between the two yellow bars, which suggests that participants did actually see that the fingerprint had less relevance to the guilt level proposition when it was left on the hood of the car than it did to the source level proposition. And the two source level propositions were not different across conditions. So in both conditions, they understood they understood the same value of the expert's fingerprint interpretation, although you could probably argue there's some undervaluing there. But where that evidence was of high relevance, it had as much effect on the guilt level proposition as it did on the source level proposition.
Just can show again just the technical. I didn't understand what you mean by belief change. It means that if it was 0.5, it becomes 0.8.
So it's subtracting the prior from the posterior.
Okay, but that's, you can understand that if it was 0.7, it went to 1. If it was 0.8, it went to 1.1. It cannot be. In fact, we know that the perception is logarithmic. Okay, I've already a comment later.
Okay, thank you. I did not understand that question, but I am sure it is very relevant. I also want to flag that this is the first time I have completed any Bayesian analyses. I thought this would be the place to try them out, although maybe I was 100% wrong about that. I guess we'll find out.
Absolutely right.
So this is a first attempt, and I would really be interested to learn more about how I might apply a Bayesian analysis to this, so I would be happy to discuss that with other people. So what do I take from this? I understand that there's some evidence of sensitivity to proposition level. It's not clear if this is due to the side-by-side comparison, the fact that people got to do a guilt evaluation and a source level evaluation one after the other. And I think it's important to replicate this where it's a between subjects design, which kind of relates to the point that Christian raised in Bill's talk. So we reran the study. This time we didn't elicit prior odds, we elicited percentages. What is the percentage chance the defendant is the source of the fingerprint at prior and posterior? And so each person only got one proposition level to evaluate in this particular study. Here's the demographics, and here are the data. The pattern is remarkably similar, even though the last one was in terms of probabilities and this one is in terms of percentages on the dependent variable. The interpretation across the two studies is very similar, and the same interaction effect is there, such that there is a bigger difference between the source and the guilt level interpretations for the less relevant evidence than for the high relevant evidence. And there we have some statistics. What I do want to flag is the effect sizes on this interaction effect are very small, and the Bayes factor is not in a zone where you would be screaming it from the rooftops. Although I don't think that's one of the verbal conclusions you're meant to use in relation to interpretation of Bayes factors, but screaming from the rooftops I think is probably a useful descriptor. So I think these data suggest that proposition level does matter. I think it shows us that people understand when they're updating their beliefs that the evidence has to be relevant to the hypothesis that they're updating. It's a pretty obvious logical fact, but it's nice to see that people do respond in that way. I think it's important to flag that the effect size, particularly in the between subjects design, is very small, and given the manipulation, which was quite extreme, from here there's an innocent explanation which almost renders the fingerprint useless, to here there is no innocent explanation and the fingerprint is in a place that's incredibly incriminating, to only get a quite small effect size, I think tells us that there's a lot more individual difference going on in our sample than there is the effects of these particular manipulations. So I think it's unlikely that this is accounting for large proportions of the undervaluing that we're seeing, but I think it's probably contributing, and if we want to be giving the best possible representation of decision makers and their ability to apply Bayes' theorem, then I think we just need to iron some of these design elements out. There are lots of limitations, and I'm sure there's many more than those that I have listed here. These are brief trial scenarios. It's not real jurors. It's not deliberation. And what I'm hoping to do is to understand what people might go into the jury room with, accepting the fact that we know very little about what then happens once they get to the other side. And I guess my naive assumption is if we can send them into the jury room with more accurate information, the outcomes are likely to be better. So my summary of what I think I've presented here today is that although jury-eligible respondents may not necessarily be good Bayesians, they're clearly engaging with the evidence in sophisticated manners. I think we can pay closer attention to Bayes' theorem in designing our studies. I think it's helpful to see it formalized like that and to design alongside that information. And I think there is value to be taken from comparing and contrasting decision makers' performance with Bayesian expectations. I think it helps us to understand how we might refine and improve the decision making that's being made. Thank you very much. Oh, there's too many hands.
Many questions. Seeing as I cut you off, you want to have the first question?
Actually, this applies to your work as well as Bill's.
Same question.
I liked them both, each of you quite properly pointed to lots of limitations, so I'm not sure where it takes us. I just want to ask or emphasize one limitation in particular. That when you, in essence, give these phrases and look at equivalence, you're taking a sentence or two out of what in court would be perhaps an hour of explanation, examination by a witness. And I'm not at all certain that if you had someone explain how you did the fingerprint comparison, showed the diagrams they might show, or with DNA, went through that, and if you had a direct examination to kind of explain, maybe say in 3 different ways what you mean, that these results would tell us anything about what's going on in court. So more than a question, though you can comment if you disagree, I would love to see further experimentation. To begin, the simplest is maybe have a 5-minute video of the witness as your stimulus instead of a paragraph that's written.
Sure. I think Bill's collected some data in relation to this.
I've had 5 and 10-minute videos of a very qualified witness, this person, Jeff, and we've been working with that.
Great. And what are you finding?
Still some difficulty with people understanding what a likelihood ratio is. So a lot of fallacious interpretations. Yeah, but I wanted to say one other thing to you, Bill. There's a lot of debate among American forensic scientists now about reporting standards. So, a lot of cases are resolved based upon the written reports without any testing. Probably the great majority of them. And so, part of what we're concerned about is what statements should be made in a report to characterize the value of the evidence. And the statements made in the reports are, in fact, fairly short statements of the type we're looking at. So, so at least we want to know how those statements are interesting.
But this may be American law. There are serious confrontation clause problems with that, which means that very often when the reports are admitted, they are by the consent of the defense counsel, I think.
Yeah, no, but
so in a sense, it's not being disputed. The issue of interpretation remains the same.
We're concerned about lawyers' understanding too, because the great majority of cases are resolved through negotiated
And
courts, right?
I would add to that I think I don't know about what's going on in Bill's lab, but I think I'm increasingly moving away from lay decision making in relation to this, and more towards jurors, because I think towards lawyers. I think because they're the ones who most often make decisions about what they believe the probative strength of this report is about, and that plea deals and various other things are made on the basis of how compelling they believe this evidence is. So I know we do talk about juries a lot, and I do talk about juries a lot, but I see this moving more into a space where legal practitioners' comprehension is more relevant, I think. Juries are a small proportion of all trials, and well, not trials, of all matters.
I think that's a really good point.
It's very interesting talk, and it's all in the equivalent of a hospital. It's very clean, it's very sterile.
It is.
You go into court and it's a cesspit.
Yeah, that's a nice description.
Well, it is in comparison, and you can get a lawyer. You can be very confident when you go in, and you may have written a good report. The jury don't get the report.
No, they don't
get
always.
what that lawyer presents, and
Yes.
it's the clever lawyer
Yep.
that actually is instrumental in the outcome.
Yep.
If you've got an incompetent lawyer, a competent lawyer, very often the evidence doesn't quite matter so much because the lawyer can persuade black as white.
I think there are certainly elements of persuasion that come into people's decision making, but I think there are lots of interesting questions that can be addressed even in the medically clean environment. I think it tells us what kind of things we might need to pay more attention to in the trial. If we see these effects going on in laboratory studies, I think it points to something that we need to consider in the real in vivo environment.
Well, I think the sample that you take needs to be more realistic.
The sample of participants?
People, yeah.
I think, you can always have better samples. I wouldn't doubt that.
Okay, great. Kristy?
Yeah, thanks. Could you go back to the first experiment with the 2 peaks?
Yeah,
Because it seems to
not
me
a touch screen. Oops. I'll get there.
an explanation for the 2 peaks.
Yeah, you can keep talking. We're going to get there.
Yeah, could be that the question you asked was, what is the probability
Yep.
of innocence? And it seems to me that's an ambiguous question.
What would
So,
you?
move
Oh,
on.
sorry. What would you prefer? What do you think is better wording?
Well,
I don't have a pen, but I wish I did.
Yeah, because it's ambiguous.
Thank you.
Between two interpretations that
Yep.
correspond to the two peaks. So
Yep.
one interpretation would be, what is the probability of innocence? Well, I'm asked what's my private belief
Uh-huh.
that the person who is prosecuted is guilty. What would I bet on if I would bet that he is actually guilty?
Yeah.
So that would be what I would call like the epistemic probability. That's my private, unconstrained probability assessment.
Yeah.
And that would correspond to the peak where people are towards somewhere between 90 and 100%.
And the
That
other one.
basically means that people out there believe that 95% of defenders are guilty.
Other way round.
So
You've got that bit wrong way round.
innocent.
No, oh, sorry.
That's okay. That's a minor point.
So that would mean, that means that they believe that 50% of defendants are actually guilty. So that would mean, it's the left peak that corresponds to their actually. They think that the prosecution has it right half of the time. Whereas the other one is, those are the people who interpret the question, what is the probability of innocence, not as their private belief of how many people are actually guilty, but okay, what does the law instruct me to do in
And
this
so is that the
situation?
wording you would suggest?
So the second one, the first one is some kind of criminological assumption, and the second one is some kind of lay people's interpretation of the law.
Yep.
So that would correspond to what you could call then, as opposed to the epistemic probability, the legal probability, not people's genuine belief states, but what they think that the law requires of them to act as if,
So
and
what-
they act as jurors.
What wording would you suggest
So
would be
therefore,
the appropriate wording?
Exactly. Therefore, I think you need, if you're interested in the second one, you should not say is, because is kind of hints at what's the actual
The
probability.
true state
but
of the
something
world,
like,
yeah.
Okay, what does the law constrain me
Okay.
to act as if the probability was, or something
What
like
should
that?
be your starting?
What should it be?
What does the law instruct me to be my starting point, or whatever, something like that. Something that highlights that it's something instructed by the law
Sure.
and not my private belief.
It's great feedback.
But
We've
the line
got
structure
Norman,
is
then Bernard, then Julia.
I feel like I'm not going to be able to answer your question anyway.
The question what the law instructs.
I would, it's a different.
Continue discussion, sorry.
No, no, no.
I'm saying, I'm cutting so you get all short questions and then we'll finish. It's very short.
Your conclusion that you thought they might not be good Bayesians, actually I'm not sure is actually supported by what you said, and also I think this relates to Bill's thing. What it actually might be showing is that they are actually good Bayesian network people because they
Sure.
were putting in the additional
Sure.
big hypothesis.
Yeah, no, I don't mean to disparage their decision making, and the way that I was invoking Bayes in that sense was in terms of the magnitude of their belief updating. But I think what the last two studies show is that they are actually thinking in complex ways in line with what Bayes' theorem would suggest. So I would agree with that.
You know, short question?
Sure, but
Bearing in mind I may not be able to answer this, I feel like I'm going to find this difficult. Okay, all right.
No. The first one, okay. No comment on the jury. I think your comment was fantastic. So anyhow, I have some comments on the likelihood. This is a bad name. The technical name likelihood in statistics, which confuses people, and likelihood ratio is the same. Second, okay, when from the title you were talking about the weight of evidence, and you have the analogy with sound and light. I was hoping you were recovering the weight of evidence of pairs, of Alan Turing, which is in a logarithmic scale, it has a better perception. Okay. The philosopher philosopher Charles Peirce, okay, he proposed the weight of evidence in analogy of decibel and light value we use in photography, because our perception is not linear, okay. And then what you change, it is increments in log, what Alan Turing was calling during the war the decibands. So the band was the logarithm of 10 of the ratio of what you call the base factor. Okay, decimal was they were in Blanchard Park. They were using the decimal to decide if they scored. Sorry, but now the prior 50%. I think that
Is this a question?
Yeah, it doesn't happen.
It has to be a short comment.
Yes. Okay. I propose as a question. Okay. Are the people in this survey?
This one?
Do they think that the policemen are really idiots? Because when they carry somebody to the trial, okay, they have some experience. Unfortunately, I'm afraid they suffer of the bias, what Daniel Kahneman, perhaps you know, we call the availability bias. Because the people hear of mistakes of the policemen, but usually policemen do not do mistakes. Okay.
I'll take that as a comment.
That's an inexperienced man.
This is definitely a discussion.
I don't think I'm coming to the discussion.
But I think the logic is important because otherwise you can't express fine huge distinctions on a percentage scale. I think that's actually a problem with a lot of this. You do need a log scale actually to get in. Bernard, you want to?
Yes, I'm afraid I'd like to question your starting point. Evidence law textbooks,
Don't be afraid.
by and large, say that the presumption of innocence is no more than a restatement of the burden of standard of proof.
Yeah, I don't necessarily agree with that interpretation. There are others who don't agree with it as well. I'm not the only one.
There's at least one US Supreme Court that suggested something else, and Whig law subjected it to withering criticism and said that it's simply a restatement of standard of proof plus a warning not to double count the evidence that led to arrest and so forth.
Sure. No, as I said, there are many interpretations. I don't particularly subscribe to that one, but I
base the prior on anything other than a logical assessment. You start buying into all sorts of problems like how heavy is the thumb on the scale to be?
well, I mean, there's a finite amount of heaviness it can have.
Okay, no, that's a good point. I'm sorry guys, we're going to have to take a break now, but I'm sure Kristy has had enough.
Yeah, I'm done. Thank you.
We'll pick up a lot of these